So hopefully everybody has the materials that they need to be able to move forward and go through this. And you saw my email of what we're going to be addressing and dealing with. And hopefully that made some good sense to you. And this is kind of a follow-up to our previous classes. And even though technically we call this a Contracts 101, as I mentioned in my email this morning, these concepts, even the ones we talked about before, are valuable concepts whether you're a very new agent or a very seasoned agent. These are concepts, and it will probably not be a surprise, might be to some, might be a surprise to the new agents that many of the questions I get that are kind of fairly basic questions come from very experienced agents. And the reason a very experienced agent may ask a question about something that on the surface is kind of basic, they've just never had that experience before. They've really never dealt with that specific problem. Now, my concern with that, a seasoned agent should be able to have a system to analyze the circumstances and come up with some way to go through it and say, okay, you know, here's where it is and here's what can be done. And this is different than what I had last transaction or last month or whatever. And that's one of the things that in a future session, we're going to talk about application of systems so that we've got that ability to look through it. It's like one of the things, I'll get a phone call from an agent, new or old, doesn't matter, and they'll give me a scenario and they'll say, they'll ask me, says, so what do I do now? Well, that's not the right question. The right question is, what does the client want to do? And when you go through the process, you look at what you're doing is you're advising your client. Now, probably a more complete question, it's really what the agent is thinking, is Bob, given all this information, what do you think I ought to do in advising our client? And as we look through it, because sometimes, you know, our ability to do that. In our system situation, we look at our information about the big picture and all the things that we have that we know to help us advise. One of the things that hopefully these classes are doing in these basic things is helping you, and we'll continue that with the questions we've got, the 18 questions here, is helping you understand the value of you being familiar with the contracts, what's in the contracts, what the parties have agreed to, and the steps of a transaction. And I mentioned this before, and if you haven't experienced it, you will experience it, where a client is not clear on the very basic, simple process. How do they make an offer? Who does it go through? And how does the other side get it? And then how do they accept it or send it back? You know, they just may have never had that. Sometimes, you know, you'll have a buyer and on the surface, they appear very experienced. And they bought and sold houses over many years. But this is the first time that they've done it in a pre-owned situation. Before, every property they bought was a new home. They go in, talk to the builder sales rep, deal done, move on. They didn't have a realtor there taking through the whole process and understanding what's going on. And that just creates an entirely different world. So let me remind you as we go through and we deal with this, it's really important in these classes that we learn from each other. You know, one of my favorite little sayings, every transaction you do changes what you do in the next transaction. And so what we want to do is be able to, as we go through and deal with these concepts, we want you to be able to ask questions, mute yourself, ask questions, make comments, give examples, so that we can learn. Because it's not a casual statement, but every transaction you do changes what you do in the next transaction. That's a really, really important concept. If that doesn't happen, it means you're not paying attention. You don't have an open mind, and you're not really learning from each transaction, because each transaction will be a little different, and new and different things will come up. because you're dealing with people. Even though the contract forms are the same, you're dealing with a different transaction every time and thinking about different kinds of things. I had a very experienced agent have a situation fairly recently in which there was a question about an item in paragraph 2C where we deal with accessories, not improvements, and it was not clear exactly what was included in this item. And it dealt with swimming pool equipment and maintenance accessories. One of our problems is that's not a well-defined term. We don't know if that Polaris floating around in the pool is included in maintenance accessories. Buyer almost certainly thinks it is. Seller may not. And so a clarification of that is really important. And once you've gone through that experience and you've had that in a transaction where it created a challenge, you'll never have that transaction, that problem in a transaction in the future. Because next time when you've got a listing and you've got a seller with a pool and a Polaris, you'll know to have the conversation about whether or not they're going to exclude that or not as you work through the process. So you'll learn in every single transaction. Any comments or questions on that as we kind of look to moving forward and working through it? And I always have to pause and give you time to unmute yourself or raise your hand or whatever. And I'll kind of try to semi-pay attention to things in chat. Anything before I do that daring next technological step of trying to share my screen? Okay, we're in for it now. Okay, so I'm going to share my screen theoretically. And this is the handout, the 18-question handout. And along with this handout, as you scroll down it, you've got the contract and the various addenda. So everybody should already have that going through it. And I'm able to put it up and work through this process. Now I have the ability to still have the gallery view or anything. This totally takes away from that. And okay, I was trying to work out where I could still see some of our fine folks here. Okay. Okay, so everybody have this ready to go for the first question. How much time does the lender have to approve the property for the loan? So I'll ask these questions. I want everybody to think about it and unmute yourself and say, well, Bob, here's what that is. And what I want you to do is not only tell me about this, but also talk about where you found the answer to that. Anybody have any good guesses here? Is everybody comfortable with the concept that the lender does need to approve the property if there's financing? Everybody understands that? Does anybody say, Bob, that's new, I didn't know we had that?
This is Renee.
Hello, Renee. What do you think? No, I think she's
sunny skies. Weekend forecast mid-80s with some shock.
We simply
okay. So if you scroll down, look at your material, you'll find in the third-party financing addendum. I'm gonna figure out, can I move this up here? And I'm talking to my co-worker here, my technological assistant, my daughter Julie. I move this up, get this up out of the way, kind of. Okay, so if we scroll down and go to the material, which you can do that physically if you want to, one of the addendums that you have is the third-party financing addendum. And you'll notice on page 2, on page 1, you got approval of financing, and then on page 2, very top, you've got paragraph 2B dealing with property approval. So in the concept, And all these things we're going to talk about, all these timelines, these are things you automatically need to know because your client's not paying attention. And you need to know, the timeline. Now, there's a little bit of a trick in the question itself. It asks, how much time does the lender have?
So, Bob, it depends.
A lot of things it does depend, doesn't it? Laura's right. So here's our challenge. The lender's not a party to the contract, are they? Everybody understand they're not a party to the contract? Everybody good with that? What does that mean? If you're not a party to the contract, we can't create any obligations for you. We can't say to the lender, for example, in paragraph 2A, buyer approval. You got 15 days in there. You can't say to the lender, okay, lender, you have to approve the buyer in 15 days. Well, they don't. They may not even have ever read the contract. Hopefully they have. But that's a timeline for the contingency for the buyer to be able to terminate under buyer approval. So the first concept here is we've got to be working as agents, both sides, buyer and seller agents, with the lender, the buyer's lender, as a team to deal with this. And part of it is to understand the timelines. And the timeline for property approval is one of those things that it establishes and talks about the lender's underwriting requirements, talks about some things it may include, like the appraisal, insurability, repair, so forth. But the way it creates a timeline, and the timeline is going to relate to the buyer being able to do something. The buyer may say to the seller, my lender does not approve your property, and therefore I'm going to terminate the contract because, I'm approved, I'm solid gold, but your property, Mr. Seller, is not acceptable to my lender, and so I have a right to terminate the contract. Well, you'll see in paragraph 2B, there's a timeline there. You see when you get on that third line, talks about not later than 3 days before the closing date may terminate this contract by giving seller one, notice termination, and there's a promulgated form, buyer's termination contract, and then a copy of a written statement from the lender setting forth the reason. Now, we've always felt like we kind of had that anyway. We always felt like if the buyer's lender is not going to approve the property for whatever reason, and most often it's value, but it could be other reasons, we always felt like if the buyer should have to give that information to the seller to have a right to terminate. Well, it was never language that was in there. It's there now. Starting with this particular contract form, that language is in there. And it's so if the buyer is going to terminate as a result of the buyer's lender not approving the property, they've got to do that before the third day prior to closing. What that means is this property approval contingency goes away on that third day prior to closing. So this is an important contingency that the buyer may totally lose out on if they're not paying attention to the timeline. Where this comes in the most often is you're in a situation, and in some areas, appraisals are hard to come by in a timely manner. And you may have a transaction that's trying to close in 15 days or 20 days or something like that, and your challenge may be getting that appraisal done. Because if the reason the lender is not going to approve the property is value, it's the appraised value, then they have to have that appraisal to be able to send something in writing that you can send to the seller saying, hey, here's why they don't approve it. Which means as an agent, since your buyer's not paying attention to this, and they're not, as an agent, you need to pay attention to the time frame. And if you don't have that appraisal by about the 5th day prior to closing, certainly by the 4th day prior to closing, then what your buyer needs to do is request to the seller to amend the closing date to give them some more time, because you're about to lose the property approval contingency. Unless they've got that contingency somewhere else in the contract, they may have it for buyer approval. I mean, they may have, if they're going to close in 20 days, they may have 20 days in buyer approval. Not unheard of, bad for the seller, but the buyer may have been able to negotiate that. So the buyer still has a timeline there. But if that's a much shorter time frame, And let's say, if we got a 15-day time frame for buyer approval in 2A, and we're looking at a closing date that's maybe 30 days after the effective date of the contract, and then here we are, 5 days before closing, we still don't have the appraisal. The buyer's about to lose that contingency, so they better take some action. There's some other right of termination or whatever. Do I have a question there? I see somebody's. No question there? Amaryllis? Okay. So the timeline in question 1, and let's take away the lender of how long does the lender have, because we know can't make the lender have a time frame. It's here's what the buyer and seller have agreed to time-wise in the contract. And so given that, as the buyer's agent, you've got to pay attention to the timeline working through it, because the timeline for property approval contingency, which is a very important contingency. That contingency ceased to exist once you hit that 3rd day prior to closing. So unless the buyer and seller agree to change the closing date to give some more time there, your buyer loses that contingency, which means they could be held in default if they don't close, because the lender, just say 1 day prior to closing, the lender says, oops, we finally got the appraisal in, can't approve the loan. And the buyer says, well, then the property's not approved by my lender, I get out of the deal. No, you don't, because you lost that contingency. Your timeline killed you. Unless it's an FHA or a VA loan. In FHA and VA, this timeline that we've got in 2B does not apply. And you'll see that language down in paragraph 4, very end of that first paragraph in 4, FHA VA required. It says the very last sentence, the 3-day notice of termination requirements in 2B does not apply to this paragraph 4. Evidently, the broker alert committee, when they made this change in third-party financing, hadn't thought this through, and lenders contacted the people on the broker alert committee and said, hey, you've got to change this, because for FHA and VA, that still goes all the way to closing. So if you're dealing with an FHA or VA loan, this property approval contingency literally goes all the way to closing, just like the old property approval contingency used to be. Questions on that? So in question number 1, if we take the lender part out and we basically say, what's the time frame for property approval? For a conventional loan, it's up to that 3rd day prior to closing. For FHA VA, it's all the way to closing. Question? Comment? Or is that just so incredibly clear you say, wow, that's really basic. I understood all that. We good?
All good.
All good. Okay, so we good with number 1. So number 2, what is the total amount of time representing the parties, or assuming the parties don't change it, that the seller has to deliver the title commitment to the buyer? Now, you will see in the contract itself, we deal with the title commitment on the 2nd page of the contract, and this is in dealing with paragraph 6B. So what's the total amount of time that the seller has? And it's the seller who's obligated, because you can't make the title company do it because they're not a part of the contract. So somebody help me have a sense here of how much time does the seller have to deliver the title commitment to the buyer? Pardon me? How much time? Is that Brian? What do you say, Brian?
I'm sorry, Bob, my phone clicked over to unmute. I don't have a good answer for you. I'm driving. Not that that's an excuse,
Okay.
but I don't have a good answer.
Okay. Anyone else? What's the total time it talks about in paragraph 6B for the delivery of the title commitment? And we do understand the timeline is not tied to the effective date of the contract. It's tied to when the title company receives a copy of the contract. So how much time do we give them?
20 days.
Okay, so there is a 20-day timeline there. Is there also a provision for some additional time beyond that 20 days? You see that phrase about a little past the middle of paragraph 6B where it talks about will be automatically extended up to 15 days. So that if you're not able to do it in that 20 days, it appears we get another 15 days. But you got that little catchphrase in there. Not, up to 15 days or 3 days before the closing date, whichever is earlier. So if you're going to have a closing and it's going to be 25 days after the effective date of the contract, you don't have 35 days, do you? You've got the original 20 plus an extra 2 days because you've got to get this to the buyer no later than 3 days prior to closing. So it's the earlier of that timeline or the 15 days. That 15 days doesn't allow the buyer to automatically extend the closing date. So it's 20 days plus however much time there is. If your closing is not for 45 days down the road, then that seller would have 35 days to provide that title commitment to the buyer, wouldn't they? Paragraph 6B, commitment, gets passed over a lot. It's one of those paragraphs, even being a subparagraph, that doesn't appear to have any choices, no boxes, no blanks. And it's one of those things that we just presume title company is going to take care of everything, so it's just not a problem. And generally they do, but it's important for us to be aware of the timeline, especially if you're going to have a closing that's going to be less than that 35 days. You need to coordinate with the title company to make sure they're able to get the title commitment within a time frame, because if the title commitment doesn't get done in that time frame, it's going to create rights of termination for the buyer. So you need to make sure that you're on top of that. Anybody have any comments or questions on that? Did you guys have pasta for lunch and you're napping right now? Is that what we got here? Okay, so we're already on question 3. Did 1 and 2 make good sense to you? Were these things that you kind of knew, but you had to reaffirm how that really worked? Okay, so 3. If a seller is going to provide the new survey, how much time should you give the seller if you represent the buyer? And how much time should you give the seller if you represent the seller? So being a survey issue, it's going to be a paragraph 6C issue on that same page where you just had title commitment. And you'll see that we've got 3 choices in the survey, and the third choice, 6C3, is where the seller is going to provide the survey at the seller's expense, which is what relates to in number 3. So there's a blank for a number of days there. So you represent the buyer and you've negotiated in the contract for the seller to provide to your buyer a new survey, which to me it sounds like a good situation, because we want a buyer to have, we want them to have a new survey. And now we're going to get the seller to pay for it. So how much time should you give the buyer, even though you've negotiated a good expense here for the seller, buyer gets a new survey, we want to make a good offer, a reasonable offer. So what kind of things are we going to think about as you represent the buyer about how much time you're going to give the seller to order up that new survey? Any ideas? $20 days, 30 days, 5 days before, 3 days before closing, Is there any thoughts there about whatever?
Bob, this is Brian. Is 18
Sure.
days an appropriate amount of time?
Well, it could be, but what's it going to be tied to? The number of days you're going to give the seller, because the concept is once the seller orders up a new survey, the seller's going to owe for it, whether it closes or not. So the concept of the timeline, seller's going to want this deal to look pretty good before he orders up a new survey. Now, it's more helpful in the seller circumstances that if he orders up a new survey and he's got a new survey and the deal falls apart, well, he's got a new survey he can almost certainly use on the next transaction. So it's not a totally wasted deal like it would be for the buyer when the buyer orders up a new survey, which we look at in another question. So the seller's going to say, well, I want to get past the option period for sure. So if you got a 10-day option period, you want to get past that. You probably, seller says, and I want to get past the financing time frame. So we've got 15 days in paragraph 2A dealing with buyer approval on third-party financing addendum. So seller says, I want to get past the option. I want to get past the financing. So I probably don't order up a new survey. And the time frame that Brian threw out, 18 days, is probably reasonable under those numbers. He's getting past the option. He's getting past financing. Things are looking pretty good. A seller may say, well, in addition to that, I want to see if we've already gotten an appraisal and make sure that we're looking good on the appraisal before order up survey. So the concept is when a seller is ordering up a new survey for the buyer under 6C3, the seller is probably going to order it up as close to the end of the transaction as he can, wanting to get it to the buyer in a time frame before closing so the buyer has the time to review it and object if necessary under paragraph 6D. So that 18-day time frame that Brian threw out could probably be good given those other numbers. But if you've got a closing that's going to happen in 45 days, you may well see a smart listing agent representing a seller say, okay, we agree to pay for the survey. We close in 45 days. We don't want to order up a new survey until 35 days into the deal. A little bit more towards the end of the transaction. Question? Comment? So that's if you represent the buyer. How much time you give seller. So does that change any at all if you represent the seller? Probably not. If you represent the seller, you're going to try to protect your seller and give them enough time to see this transaction looking really good. So probably that same 18, 20, 35 days for your seller or up a new survey is probably going to be a timeline you're going to use in either case. So that would work out. Questions on that? We go to question 4. In 4, buyer's going to obtain a new survey because they paid attention to your good advice. What are the variables to consider to determine how much time the buyer should have to obtain a new survey? I need to stall so I can put the pressure on somebody to give me a good answer. I got some really smart people on this call. Marcia, for example. Brian, James, Laura.
You probably still want to wait close to closing because the buyer's going to have to pay for it whether he closes or not.
Yeah, in the buyer's case, since he's going to owe for the survey once he orders it, he wants to make sure the deal's looking good. And so the buyer may well also wait until closer to closing before he orders up a survey, because if this deal doesn't close, buyer's got a survey that he really can't use. He's got a survey on a house he's not going to buy. So the buyer's certainly going to want to get at least through the option period, probably the financing, probably wait until he's ordered up an appraisal. So if you've got a 45-day closing, the buyer probably is certainly going to wait till about 35 days or somewhere towards the end of the transaction. So James is right on that timeline. Now there's another factor, another variable involved in this, and it deals with the objection time frame in paragraph 6D. In 6D, buyer has a right to object. And one of the things that buyer has a right to object to is a survey. There are three things a buyer, can deal with there: the commitment, exception documents, and survey. And so that number of days in 6D for the buyer to object is tied to the receipt of the last of those three documents. And typically, in the case of a new survey, the survey is the last thing they'll receive. Probably will receive the commitment by a fairly reasonable time early in the transaction, and survey is the last thing. So because of that, as the buyer looks at his rights of objection, recognizing that the number of days he has to object cannot extend the closing, because it's that number of days or closing, whichever comes first, whichever is earlier. And so the buyer, if in my example, 45-day closing, they put 35 days in there, and that's when they get the survey. Let's just say they receive the survey 35 days, and say in the small blank in 6D, they've got 3 days, which is a fairly good typical timeline. And once they receive the survey, if it's the last of the three documents, and now I have 3 days in my example to object to matters on the survey, particularly if there's something in the big blank that they want to be able to do to the property, such as build an in-ground pool, and the survey shows there are easements there, they're going to get into a problem. So, as you look at the buyer in this situation and work through this, the variables are much like what we talked about in paragraph 3. They go through the process. We want to make sure this deal looks really good, because the buyer doesn't want to have to pay for a survey on a house he's not going to buy. And that's big. But you also need to look at the objection timeline that you're dealing with there. Question on anything so far? And please tell me, you don't have to tell me, but please, I want everybody to assure me that your advice when you represent the buyer is to tell them they should get a new survey. A buyer should get a new survey. A buyer should never do what's going to happen in question 5. They should never be getting an existing survey. I see that thumbs up from Laura. Good job. That's exactly right. They need a new survey. They just really do. So getting to that question, number 5, you have the buyer. So how much time do you want for the seller to provide an existing survey, which is 6C1? You got a blank for a number of days there. So you got represent the buyer. How much time do you want to give that seller to produce an existing survey? And of course, also the T47, which is notarized affidavit. How much time are you going to give them? 3 days, 5 days, 10 days? Unlimited? Leave it blank because it's too hard to guess. What do you think?
Probably 5 days max in case there's an issue. They need to go ahead and have time to get the other one purchased.
Yeah. Yeah. And James is right. A fairly short time frame, 3 days, 5 days, something like that. The only variable that comes into play, and it comes into play with the second part of this question, if you represent the seller, sometimes the seller has an existing survey and it's not handy. Maybe it's out at the farm. And so they'll maybe go out next weekend to the farm and get it. So they may need a little more time just because of availability and working through that. Maybe the seller is in a position where it's not convenient for him to get the T47 notarized. And so he needs a little bit more time to be able to do that. So unless you've got variables like that that create a little longer time frame, it should be a fairly short time frame, 3 days, 5 days, because frankly, they either have it or they don't. Now, here's something I would ask of you to please not do, and I see this, and I don't understand. I see a buyer make an offer and check off 6C1 when they've got a seller's disclosure notice, and in the seller's disclosure notice, the seller has answered the question saying they do not have a survey. Well, the seller doesn't have a survey. Why in the heck are you going to check 6C1 asking the seller to produce an existing survey? me, that sounds, one, like you're really not paying attention, or two, a little bit tricky, trying to trick the seller into going and accepting a great offer, knowing that they now are going to have to buy a new survey for your buyer. That doesn't seem quite right. So if you see the information, if you already know a seller doesn't have a survey, then you need to move to 6C2 or 6C3. And that's going to be a negotiation of the expense of those two things. Any question on that? Does that make semi good sense there? We good? So while we're talking about a reasonable number of days, let's look at number 6. What's a reasonable number of days for objections by the buyer? So you've got that small blank in 6D. And it's a number of days or closing, whichever was earlier. You don't get to extend the closing for the number of days. So how much time does a buyer have or should have to be able to make objections? Any ideas? A lot of time, a little time. And remember, the number of days is not tied to the effective date of the contract. It's tied to the receipt of the last piece of information, the commitment, survey, or exception document, those three things. So that's what it's tied to.
Hey, Bob, is 5 an appropriate number of days?
It's probably an appropriate number. 5, Brian, is a good number because here's the concept. When the buyer gets those 3 documents, he may need a little time to check things out. He may need to check with the city, check with permits, check with something to see if there's going to be a problem. So he may need, and he may get his last document on a Friday. He might need to get through a weekend, maybe even a Monday holiday like we just have. So 3 to 5 days is probably a reasonable time frame. If it's a much larger number of days, then we almost certainly have either a buyer has some serious challenges with what he needs to investigate for his rights of objection, or they're tying it to the effective date of the contract, not to the receipt of information. So it needs to be something that's reasonable, 3 days, 5 days, something in that direction would be probably a reasonable time frame. And one of the things we need to think about, when we're talking about timelines and all these things, all of these are going to impact, if you've got the buyer, all of these are going to impact on how attractive your offer is to a seller. A good listing agent is going to understand the importance of these timelines. If you have timelines that are way out of whack, asking for too much time on something, not giving enough time on something, that's going to impact on how attractive your offer is. Your offer may be at a really good price and maybe otherwise a good offer, but you've got a situation there where there's some timelines in there that just is way beyond what it should be. So when you understand these timelines, you understand how this affects the offer in the contract, and it becomes really important. So as we look at these timelines and what's reasonable, what's typical, what makes sense, there's a concept behind that. Question on any of that so far? Okay, question 7. We're talking about the seller's disclosure notice. And the seller's disclosure notice is cleverly disguised and hidden in paragraph 7B, where you see the title says seller's disclosure notice. It was one of those things that when I served on the Broker Lawyer Committee, the attorneys on the committee, who were generally respectful of those of us on the broker side, every once in a while, that really deep-seated thing they had about realtors came out and they said, we got to be really clear on these headings because, those realtors are not all that bright. So we got to really make sure they understand what's in that paragraph. That's why you'll see the heading for the paragraphs are very good. They're very descriptive. They really tell you what's going on. And everything in 7B relates to the seller's disclosure notice. Now, so the question we have with number 7, if 7B2 is checked, that means that the buyer does not have the seller's disclosure notice. What is a good time for the seller to deliver the seller's disclosure notice. In other words, how much time should we have there? What do you think?
Within 2 to 3 days.
Okay, 2 or 3 days. Okay, why?
Because ideally, you'd like to have it within the option period.
Okay, why?
So the buyer can be well aware of what the seller is aware of.
Yeah, so aware of the seller's opinion by condition of property. So if there's some big surprises there, the buyer's in their best negotiating position during the option period. So it really is, Laura's right, it's a good idea to have this be a fairly short time frame while the buyer still has other rights of termination and other ability in their due diligence. So it probably should be a shorter time frame. Now, having said that, one of the things we also need to keep in mind, this does not create an obligation of the seller. If we put a timeline in 6B2, let's follow Laura's
It's Jeannie.
example. Huh?
Jeannie Wiesner. It's Jeannie.
Oh, hello, Jeannie. Did you come
She's
up with
helping
that?
you out.
Okay, so.
No, that was Jana Ward.
Oh, I'm sorry.
Okay, so let's put
Apologies.
5 days in 7B2. So we got 5 days in there. So we got 5 days, and the seller is a busy person and doesn't get this to the buyer within the 5 days. What does that do to the contract?
Absolutely nothing.
Does it terminate the contract?
No.
No, it
No.
doesn't terminate the contract.
In fact, it has no effect on the contract.
It gives the buyer the option to terminate it.
James is right. It does give a buyer a right of termination. However, keep in mind, the buyer had that right from day one of the contract if 7B2 was checked. If 7B2 is what goes live in the contract, the buyer has just picked up as a minimum a 7-day free option period. Because the buyer has a right to terminate from day one until they receive the seller's disclosure notice, and then 7 days afterwards, or closing, whichever comes first, to terminate for any reason. So it's not a default to the seller because the remedy for the buyer is right there. Buyer can terminate the contract. So what the number of days in 7B2 becomes is kind of a negotiation, because one of the things that is, it's a little, I don't know whether ironic is the right word or interesting or whatever, but I constantly am amazed, and we see this also in the mandatory HOA addendum and A1, we'll talk about that a little bit later. I'm always amazed at how agents haven't thought through this, and they don't realize what the seller is giving up if they diddly-daddle around and don't get the seller's disclosure notice to the buyer. They don't really read it. In fact, they look at this timeline as a requirement of the seller. I've heard buyers say, well, seller didn't do it in 5 days, seller's in default. I said, well, okay, so if you want to hold the seller in default, what's your remedy? Well, buyer can terminate the contract. Well, you're right. But it's not because the seller's in default, it's because that's what it says in paragraph 7B2. What this becomes is a negotiating thing. If you got a buyer who says, you know what, I don't really care what the seller says. This is a seller who's never lived in their property. You know, this is someone who lives out of state and they inherited the property. They still have to give a seller's disclosure, but they don't know anything. We're going to do inspections anyway. So let's give them a really long time. Let's put 20 days in here. And maybe they'll get lulled into this false insecurity and take their time getting it to us. Because if they wait till 20 days, they just gave us a 27-day free option period. So this becomes a little bit of a negotiating thing. If you're on the buyer side, now if you've got a buyer who says, you know what, it's absolutely critical. These people have lived in the house from day one. I want to know what they know about the property. So I want this as soon as possible. I know we're going to do inspections, but I want to know what I can hold the seller to knowing. So if you got a buyer who's very aggressive, you're going to put a shorter time frame, warning your buyer that whatever time frame we have here doesn't make the seller do anything. The seller can still take their sweet time. And nothing the buyer can do except terminate the contract. So the number of days here is less important from a clear standpoint of technically what it does to the contract. It's more a negotiating point depending on which side you're on. If you've got the seller, you really, unless you're a seller otherwise, just really want to accept this offer. If you get an offer with 7B2 checked off, if your seller is going to counter that offer, you ought to counter with 7B1 and make sure you get that seller's disclosure notice for the other side. So this right of termination no longer exists for that buyer. Everybody good with that? Comments or questions as you see how this works?
Yeah, Bob, if you're representing the seller, can you just say that the disclosure must be accompany all offers?
Wait, say that again?
If you're representing the seller, can you just say that all offers must have that with them, that it has to just be a part of the offer?
Oh, you could, but the way you really control that is all offers must have 7B1 checked off. Because remember, the property code does not require the buyer to sign the seller's disclosure notice, only the seller. So the way you control that is make sure in any offer the seller accepts, it's 7B1. In fact, when you make suggestions to buyers about what you want to see in an offer, you know, this would be pretty good, which means you better have the seller disclosure notice downloaded in MLS so it's available to any buyer's agent. Good point.
Thank you.
So as you guys are doing this transaction and we're seeing, if you represent the seller, do you understand the impact of what an offer means to your seller if we let 7B2 be the deal? Or in some cases, if it doesn't impact, let's say, for example, you have an offer and the buyer's paying $250 for a 10-day option period, and they check off 7B2. Well, all you have to do, if it's a great offer and you sell, I don't want to counter, I want to accept this offer. Well, go ahead and accept it, and then immediately get the seller's disclosure notice to the buyer. They've got 7 days. Well, they already had 10 days in the option period they paid for it. So we don't lose anything. That's just free money for the seller. And so depending on what else is going on in the transaction, you can live with 7B2 because you'll get that to the buyer's agent right away. So that 7 days they've got doesn't mean anything in the transaction. But that comes from your knowledge of the other things in the transaction that impact on what the buyer's rights are, that impact on what your seller situation is. That makes sense?
Yeah.
Now, let's look at closing. So in question 8, how much time should there be for closing? And what are the major variables? So we're looking at paragraph 9A. And we got an on or before date there. So how do we come up with the closing date? You've got the buyer, you're going to write an offer. What are the variables that help you determine how much time you're going to have for closing? Because they're endless. They're pretty endless. A huge range. What are some of the factors that come into play? You're the buyer's agent. You're going to write an offer. What are some of the factors that come into play for you deciding on when the closing date will be? Let's just use today's example. You know, right now, we're sitting on September the 10th. So we got basically 20 days left in this month. What's going to help you determine how much time?
Is it an all-cash offer, or do they need to get financing?
Exactly. So the nature of that offer from your buyer is going to make a difference. Your buyer, generally, from a closing standpoint, is going to be in a better position to have a shorter closing date on a cash offer. If there's financing, then you're going to want to talk to the buyer's lender and say, for this buyer, for this borrower, what's our timeline? And so the lender will be able to say, you know, here's the deal. This, by the way, is where it really becomes important for you to have good conversation with your buyer's lender, have a good sense of how much that lender is on board with this transaction. Because Some lenders out there will give you a timeline. There are 2 or 3 big lenders out there that historically never meet their timeline. They just don't do it. They're big. We had one recently, and their excuse was, and the buyer worked for this big lender, one of the big 3, and their excuse was they were so busy with all the refis. Really? When you should have taken this purchase buyer on as a client, moving forward, you couldn't meet the time, or at least don't lie to us about how much time you need. So you need to have a really good conversation with your buyer's lender and really try to get a sense of how much we can trust their timeline. So one is going to be, it's cash, it can be a shorter time frame. The other is going to be from the financial standpoint. What information might you be getting as the buyer's agent from the listing agent on the value of a certain closing date? What could affect the seller's need for certain closing dates?
They need to get to their next house on a certain date.
Yeah, they've got another house they're going to buy, and they've got a timeline here. And so sometimes, because they don't want to double move, and they're buying a new house, and the new house won't be ready for 60 days, they may need a little longer closing time frame, which could or could not work for your buyer. One of the things that you'll need to make sure you do with your buyer, and if you don't actually say this to them, it can create a little bit of a challenge. You're getting information from the seller for your buyer to make an attractive offer for the seller, especially in any kind of a multiple offer situation. You want your buyer to make the most attractive offer, but you want to remind your buyer you are their advocate, and you're doing all this for them.
Kind of get everything set for a test.
Okay.
Kind of see
Okay. So somebody needs to mute themselves.
The inspector.
Okay. So as you work through it, make sure your buyer understands you're just getting this information to give to your buyer so they can make an attractive offer, but it's going to be always, you're going to be your buyer's advocate. And if your buyer says, well, you know, I can't really do 60 days because we've got a certain situation and we need to be able to get into a house. And so, you know, that's information that you're going to work through and negotiate with the listing agent, with the seller. Because what the seller's circumstances are, especially if they've got a situation where they've got a house to sell, they need to sell this house, go to another one, and they're going to create contingencies. As many of them have experienced, we end up with dominoes. You know, your buyer has a house to sell, and the house they've got to sell, the buyer buying it has a house to sell, and the seller's house who your buyer's buying has a house to sell, and the dominoes can just drive you crazy. But we have those, especially in a multiple offer scenario. And so as you work through all that, you have to deal with it. But on the closing date, you want to make sure that it works for both sides. Your buyer may be incredibly flexible. You can use that to your buyer's advantage in negotiating a closing date that really works for the seller. In fact, your offer may not be the highest offer, but the terms, such as closing date and other terms, are more attractive to the seller. And the seller says, I want to avoid a double move if at all possible. It's not the money issue, it's the inconvenience. And so if you can give me a closing date that keeps me from having a double move, then your offer is a better offer than this other one that may be higher. And so you need to look at all those kinds of things. The other thing I would ask you, you've heard me say this so many times, say, Bob, I don't hear this again. Well, you need to. Have a calendar in front of you when you write the offer and come to the closing date. Don't let the closing date be on a weekend or a holiday. Please don't do that. In spite of how often I say this, we keep coming across situations where you have closing dates on a weekend or a holiday, and you just, you know, it's a challenge. So please, you know, and not only is the buyer's agent not paying attention, the listing agent wasn't paying attention when they helped their seller accept the offer. And all of a sudden we end up with a contract, and later on we got to change it. And parties may not be totally receptive to doing that. So everybody good with the closing date? Okay. So let's get to an incredibly easy question. These were, you know, although you guys have slipped through these pretty good. We're talking about paragraph 23. We're talking about an option period. How much time should we have in the option period?
Three days.
3 days? 3 days? Did we say 3 is in 3 days?
Yes.
7
Okay.
days.
So I hear 3, I hear 7,
Yeah, 7 to 10 days.
Oh.
7 to 10 days.
It
Yeah.
depends.
It does depend.
Exactly.
Laura's right. Now, it may be 3 days may make your buyer's offer incredibly attractive, but it's going to create pressures for your buyer to do certain things very, very quickly. And it's going to keep your buyer from having an extended due diligence period to negotiate when they find out they can't build that in-ground pool. So 3 days, you're going to have get all your ducks in a row right away. Any inspections, anything else you got to do. Because remember, many of your timelines in the contract don't give the buyer the ability to extend the closing. So that closing date can be an end line for a number of scenarios in the contract. The number of days, generally, if your buyer already has a situation where they're going to need to do multiple inspections, not just the trek inspector, but a roofer and a foundation and a HVAC, and because we're seeing more and more buyers, in addition to the trek inspection, doing other inspections, having electrical, having plumbing, HVAC, roofer, foundation. So if you're going to have a number of those, then you'll need more time to be able to do that. And particularly on an occupied piece of property, as on the buyer side, as you coordinate the timing on that, it's going to be really important that you're able to do that in a reasonable time. That's addressed in paragraph 7A of the contract for the seller return. Well, you know, that's reasonable. Yeah, we can work with that. So as you go through and deal with that, because the shorter the option period, the better it is generally for a seller. The longer it is, generally it's better for the buyer. And it tends to relate to the amount of the option fee. If you're going to have a much longer option period, seller typically is going to expect a little higher option fee. Back in the good old days, $100, 10 days was, you could almost just stamp it. It was almost so standard. Now we're seeing more, 150, 200, 250, 10 days, 7 days. Every once in a while I'll see a 5-day, and you just got to make sure your ducks in a row if you have a shorter time frame than 7. And you want to make sure, look at the calendar. You've got 5 days from the effective date of the contract. Make sure you're not coming up on a holiday weekend that could really impact on your buyer being able to get inspections done and things of that nature. Are you good with that?
Mm-hmm.
So any other variables that you want to come up with or think about on how many days? I think anywhere in that 7 to 10 day timeline, and the option fee will depend a certain amount on the price of the property, more expensive the property, often a little bit higher option fee, but it's going to tie to the option period. The option fee are going to kind of work with each other.
So Bob, if they put a short option fee in and then they find something, what are the buyer's options at that point? What can they do?
Yeah, if you've got a very short option period, the buyer better make sure they can do their investigations or inspection, everything within the time frame. And what can happen, because the buyer has a lot of leverage in that time frame. If the buyer discovers some things within that 5 days, they're still in the option period, then based on that, they're in a good position to negotiate with the seller an extension of the option period. So they can say, you know what, we've got more information we need here. We've come up with a lot of stuff here, but we need more time. Because if the seller says, no, we agreed on 5 days and that's all you get, buyer says, well, have a nice day because we're out of here. And what it's cost the buyer is the cost for the inspection and the option fee. But the buyer's going to have to do their due diligence during that time frame, remembering that you've got independent investigation timelines. Just like we talked about paragraph 7B2, seller disclosure notice gives you some time. So if you've negotiated a 5-day option period but you've got 7B2 checked off the contract. Your buyer has 7 days. If they get it immediately, they've got 7 more days to terminate for any reason. So that 5 days doesn't hurt them a lot. Same thing if you're in a mandatory HOA, the buyer has 3 days after receiving that HOA docs. That's generally not going to happen real quickly. So unless the seller already has all that information, including the resale certificate, your buyer's going to pick up another 7, 10, maybe more days under that right of termination. So it depends a lot on what else is going on as how important it's going to be for your buyer to negotiate a shorter time frame. Any other comments on that? One of the things that'll happen, and I presume the Texas Real Estate Commission will adopt most of the changes in their November meeting that we proposed for the contract. And one of the things that's being proposed is paragraph 23 will totally go away. And this concept will now be put into a new provision in paragraph 5, where they're going to deal with the earnest money and also deal with the option fee together. And in the new contract version, if that's what it gets approved, you're going to be delivering the option fee to the escrow agent as opposed to the seller. So we'll see if that survives all the comments, because right now we're in a comment phase to the Real Estate Commission, and then the commission will look at all this in their November quarterly meeting. So it'll be interesting to see how that works out. Okay, now buyer approval. Let's go back to the third-party financing addendum. And on the first page of the third-party financing addendum down in 2A, we got buyer approval. We got a blank for a number of days. And so the question is, where do we get that? Where do we get the number of days for buyer approval for the buyer as stated in the third-party financing addendum? Where do you get that? Maybe more importantly, where do you not get that? It's not you. It comes from somewhere else, doesn't it? Where does it come? Any guesses? Any wild and crazy guesses? Anybody says, I don't know, Bob, that's really hard. I don't know.
The buyer or lender.
Yeah, you're going to have a conversation with buyer's lender, aren't you?
The lender.
Yeah, absolutely, the lender. Now, here's that's a simple answer, and it's got a lot of truth to it. However, there's something else. When you talk to the buyer's lender, say, okay, we got buyer approval, we got this blank in here, we need to know how much time we need. If the buyer's lender says, oh, it's going to take us at least 20 days to have loan approval, you didn't hear your question. You didn't ask about loan approval. You didn't include property approval. All you're talking about is buyer approval. And you need to make sure that lender gives you a timeline that only deals with buyer approval, not everything.
Wouldn't you want to have a conversation, especially like in a year like this, with your buyer to ask if their taxes had been done or had they filed for an extension?
Yeah. When you're talking to the buyer and you say, and talk about their lender, talk about the application, talk about what they've done, says, you want to see how far they into it. If, for example, they've already made an application, they've already had the conversation with the lender about things that Laura brought up. They've done their 2019 taxes, or maybe not even done their 2018 taxes. But you're exactly right, because when you have those kind of challenges, working through that, all of those come under the heading of buyer approval. And so that could create a real timeline here. The more time you have in paragraph 2A, the better it is for the buyer from a standpoint of being able to still have that right, that contingency, and that right of termination. Having said that, if you have too much time here, that really clouds the offer. That a good listing agent and a seller looking at this said, wow, they gave us a pre-qualification letter. They've told us how great the buyer is, and they need 35 days for buyer approval. Wow. Is there something tricky going on here? Something we don't know about? There's something we should worry about? No, what's really happening here? And so when you've got a long time frame there, either you've got a lender who's including both buyer approval and property approval, or you've got a problem buyer. Maybe the lender already knows up front, says, yeah, you know, if this were a normal buyer and he had all his docs, but we've already sat down with him, and we know we need tax data, we need, you know, more filings, we need more information on his overtime, his bonus. So it's going to take us at least 30 days, if not longer, for buyer approval. So that's good information from the buyer's lender. It shows they're on top of what's going on. You should have that conversation with that buyer, making sure they're on board with cooperating with the lender. Because what kills us sometimes is there's a financing problem, and it's not the lender's fault, it's your buyer's fault for not putting his stuff together and getting it to the lender in a timely manner. And that can be a real challenge. So if there's financing, and you wouldn't be using third-party financing if it wasn't, then you're going to be having a conversation with the lender, but it's going to be a good conversation, and you're going to really need to make sure that the buyer's lender is on board with what this buyer approval really means. Good with that? Question? Isn't nap time yet? Okay. Now let's deal with property that's located in a subdivision in which you're required to join mandatory HOA. So question 11, how long should the seller be given to provide the subdivision information if A1 is chosen on the mandatory HOA addendum? How much time should we give the seller?
I think they all need some of your Coke, Bob.
Well, they're thinking this through. They're giving it a lot of serious thought. They don't want to just blurt out with an answer and say, wow, man, that's a tough question, Bob. I don't know. It's, but every one of you have done a transaction.
I would say,
how much?
Typically, I would say 15 days as a minimum, because if you do them shorter than that, typically the seller is charged with a rush fee, and the sellers don't like that. So I like 15 days myself.
So it's a good point. But if you have a shorter time frame, then your buyer's offer may not be really attractive, because listening, he says to the seller, you know what? I've got 5 days in there. There's going to be a rush fee. And rush fee is going to be 200 or 500, whatever it might be. So I said, wow. So it says either I don't accept this offer, we counter, or give myself some more time. So from the standpoint of maybe creating something that's not attractive to the seller, you want a reasonable time frame. Now, some HOAs, even with 10 days, charge a rush fee. The Texas legislature is trying to work through restricting some of those things HOAs are doing. And there'll be some more legislation coming up in this session, which will begin 2021. But frankly, this is not high priority on the list of the legislature. They're dealing with the impact of COVID-19 on the state treasury. Because remember, legally, the only one thing that the legislature is obligated under the law to do is adopt a budget. It must be a balanced budget. That's all they're required to do in that 147 days that they're in session. So the COVID-19 has created some enormous challenges that the legislature is going to have to be faced with. So while they're going to deal with HOA, that's not the top of their list. So I think a reasonable timeline in here, recognizing that the buyer's rights of termination tied to paragraph A1 are tied to the receipt of the information, or closing, whichever comes earlier. So if we put 15 days in there, was that Jana who suggested that?
Yep.
We put 15 days in there, and the seller gets it to the buyer in 10 days. But after the buyer receives it, they've got an additional 3 days. Has nothing to do with the 15 days. The 15 days doesn't give the buyer additional rights termination time. It's tied to the receipt or non-receipt of the information. And so this, again, kind of like paragraph 7B2, dealing with seller disclosure notice, In fact, a little bit more so, this becomes a little bit of a negotiation tool. Your buyer may not be real concerned about this information. He may be moving from one part of the subdivision to another. In fact, A1 probably shouldn't be the right choice for him in paragraph A. So he's not really concerned. So he may put a long time frame here. He might put 20 days in here, maybe even 30 days. Because what many sellers and listing agents don't understand, this again creates a free option period. So if the seller gets this information to the buyer in 10 days, the buyer has just picked up a 13-day free option period. It's a powerful right of termination tied to the HOA information. And so sometimes the buyer may say, well, I want to stay in control of the contract. And as a result of it, let's give them a lot of time so it'll keep us as on buyer side in control of the contract. Does that make semi-sense? Because remember, it's all tied to the receipt of the information. But the number of days here kind of becomes a suggestion. Just like on the seller disclosure in 7B2. In fact, they've got even stronger language in A1. Let's say we got 10 days in there. 10 days comes and goes. And we've heard buyers and buyers agents say that, well, seller's in default. Well, here's the problem. You've got language in paragraph A1, next to the last sentence. Buyer's sole remedy, they terminate the contract. That's their only remedy. They don't get to sue the seller. They don't get to hold the seller in default. They don't get to go for damages or specific performance. Their sole and only remedy is to take the earnest money. And that's it. And so it's very important for us to understand this timeline really becomes a suggestion and doesn't impact on the contract if the seller doesn't meet that time frame. We kind of good with that? Now, here's the other part of this. The range of what title companies do with this information is huge. A number of otherwise good title companies you use on a regular basis, look at this number of days and they feel obligated to help the seller comply with the contract. Let's say we got 10 days in there. And so they will make sure, the title company will make sure they order up the HOA docs so the seller complies with the 10 days. That should never be done. It's not the obligation of the title company, but they do it. So you need to make sure, if you represent the seller, you need to make sure you've had that conversation with the title company who's going to be using the contract of what they're going to do with it and how they're going to handle it. Because most HOA companies, most HOA managers don't want to hear from anybody except the title company. That's who's going to order up the docs. And so title companies, in their effort to really help the clients out, many of them say, well, that time frame, I even had a conversation 3 months ago with a title company attorney who said this is an absolute obligation of the seller. And so it has to do in that time frame. So to help the seller, we always order it up. I say, well, I try generally not to argue with attorneys because you've been to law school and I haven't. I presume you passed the state bar because you got a law license, but you're still stupid. I didn't say that. I didn't say you still. But I said, maybe you should read paragraph A1 again, especially the part about the sole remedy. Seller's not in default. This is not an obligation of the seller. This is a suggestion. It's more of a negotiating tool than anything else. And we need to understand that's what's going on in the HOA addendum. So you need to make sure you've had a conversation with the title company if you represent the seller and make sure you're on the same page with what's going to happen within this time frame in A1. Everybody good with that? Now, let's look at one of our favorite little addenda, sale of the property. I did have a interesting little conversation with an experienced agent of ours, really experienced. And she had a real problem with this addendum. She's been in the business, let's say, about 10 years. And as she started out, when she called me on this, says, Bob, I've never had one of these. Now, I accept that you could have been doing business for that period of time and you never had a case in which you had a buyer who had a house to sell, or you had a seller and they were entertaining an offer with the buyer who had a house to sell. I was respectful. I doubted it a little bit because this addendum has been around a long time. But the challenge here is that she was not clear on the concept of what's going on and the impact of the dates in paragraph A and the number of days in paragraph B. So I want us to have a good sense of this because I had a conversation with one of my good broker friends, who she's the broker for a small company. I think they have about 20 agents. And she said something. I said, I respectfully disagree with you on this. She said, Bob, I think the sale of the property addendum, this contingency addendum, is a thing of the past. I think in a multiple offer situation, we won't see these used at all. Well, I don't think she's right. In fact, I see right now in multiple offer situations, these are used and can be used if a buyer's agent can really have good ammunition and sell the seller on the buyer's offer based on what's going on with the seller's house they've got to sell. Could already be under contract, could be a cash transaction, past option period could be just solid gold and not a problem at all. So I think we are going to still see this. And so my question here in number 12, determine the contingency date on the sale of the property by addendum, and then how many days should we put in paragraph B? So the contingency date you see in paragraph A, it's a contingency date because at the end of that second blank, you see in parentheses, the contingency. Guess who decided that needed to be there? The lawyers on the broker lawyer committee. We got to make sure everybody understands what that date is. That's the contingency date. And that's the date that if it's not saying, then it explains what that means. So you've got the buyer and you're going to make an offer and they've got a house to sell. And so you're going to put a date in here. And the purpose of this date is that your buyer is hoping to satisfy the contingency or be able to waive it before this date hits. Because when this date hits, what happens to the contract that your buyer's in?
Automatically terminates.
Yeah, and it's an important phrase that James is using, automatic. Only place in the contract or in the addendum of the contract where you see the automatic phrase, automatically terminates. So unless when that date hits, unless the buyer has satisfied the contingency or waived it, it's an automatic termination. So that's a kill date. So when you make the offer, while you want to give your buyer as much time as they need to be able to sell their other house, want to be able to work through that, you need to make sure this is a timeline that helps the seller understand, here's why we need this much time, and here's what's going on with our buyer's house that they have to sell. Work through this, because it's an automatic kill date. Clearly, the longer the time frame here for the buyer, the better it is for them, but the worse it may be for the seller, because at one level, although there are some feelings by some very well-respected title company attorneys, that there are some common law provisions that require a buyer to make their best efforts to sell their other property if they use this addendum. I'm really not familiar with any court cases that hold up on that, but regardless, I think the reality is this date that you've got in that second blank in paragraph A, all your buyer has to do to get out of this contract is not sell their other property by that date. If they haven't sold their other property, contract terminates and they get their money back. Now they spent money on option, probably inspections, other things, but it gets them out of the contract. If all of a sudden their situation changed and they want out of the deal, this gives them the ability to get out of the deal. What your seller needs to understand, that's really what's going on with this buyer. So they're holding their house off the market in a little bit of a wishing and hoping situation. So you should have really good information if you represent the seller, what's going on with that property the buyers need to sell. In fact, if it's local, in addition to doing a CMA, you should go see the property. You may want to see if it's under contract. You may want to see a copy of the contract. You know, you really may want some additional information about what's going on with that other property. So the number of days, the date in here, what I see most typically in paragraph A in that second blank is the closing date. So the buyer's writing an offer and he's going to close, you know, October the 15th, because his house he's got to sell is already in a contract and is going to close a little bit earlier than that. And he's negotiating to sell whatever his lease on the house he's selling, so he can get past the closing, won't have to do a double move. So he may well put the closing date of the house he's buying in this addendum. Give himself that much time. Now, the challenge with that, which is by the way, fairly typical timeline, should mean later than that, as it mentions in that notice. The challenge with that is sometimes in that contract, the closing date changes and the parties extend the closing date. When they change that closing date, if that's what they put in paragraph A, they better amend this addendum and change this date, or they could find themselves with the contract just automatically terminating. And neither party may have wanted to do that. So you need to, as an agent, if you represent a buyer, pay attention to this date. And when things are going on and the closing date changes, you need to make sure not only do you use the amendment to extend the closing date, you also went through the process and you amended this addendum and changed the date here to the new closing date. We good? Now, the second part of this question, dealing with the number of days in paragraph B. Paragraph B is our kick-out paragraph. It's our knockout. And this states that the seller can accept another offer, and it'll be on a backup basis. They ought to have that language in there, but that's what's required. Even though the seller had a right under the terms of the contract, paragraph 19 anyway, to continue to show the property and accept backups. Here the seller has accepted another offer on a backup basis. So they're in a second contract, and they have to give notice to your buyer that they've accepted this other ones. And then they require the buyer to go ahead and waive the contingency on or before a certain number of days. If they don't, contract terminates automatically. So the timeline that you have here, typically a fairly short time frame, because the seller says to the buyer, to your buyer who's got a house to sell, okay, we've accepted another offer, you've got 3 days. From the seller standpoint, it needs to be a fairly short time frame, because this other offer the seller's accepted, they're going to want to know if their offer is going to end up being a good offer or not pretty quickly. They don't want to sit around for 10 days trying to decide if this contingency is going to go away, it's going to get kicked out or not kicked out. So typically a short time frame. Now, 3 days to 5 days is fairly reasonable, because the buyer may say, well, before we can agree to waive the contingency, we need to talk to our lender or the bank or our employer or something to see if we're going to be able to really, waive this and be able to move forward and be okay. So they may need, 3 days, get past a weekend, a holiday, 5 days, something of that nature. Now, what happens is, and I had this happen with one of my incredibly experienced, one of my second largest teams in Rockwall. And he believed, in fact, he had advised some other agents that if you leave the number of days in paragraph B blank, it voids the paragraph. In his mind, the paragraph no longer applied. So the seller didn't have the ability to kick out the buyer. Well, that's wrong. What we have is a dispute on the number of days. It didn't make the whole paragraph go away. If the buyer says, I thank you for accepting our contingency offer. I don't want you to have the ability to kick us out. So we're going to totally eliminate paragraph B. We'd have to line through it, initial it, and probably in paragraph 11, special provisions, buyer and seller agree that paragraph B is zero private gender, no longer applies to this contract. That'd be really clear you're eliminating this kick-out provision. Otherwise, it applies, and what you've got, you don't have something in the blank, is you've got a dispute. And we want to avoid disputes. We have enough challenges anyway. So the number of days, 3 days, 5 days, fairly short, reasonable time frame. Any input on that?
Can I ask a dumb question, Bob?
Sure.
What good is this addendum since it does have that kick out? How does that help the buyer in any way, or does it?
Well, it does help the buyer, and it creates a little bit of an incentive for the seller to accept the buyer's contingency offer. And the buyer, what we need to understand is this doesn't give the seller a right to absolutely terminate the buyer contract, because the buyer's still in control. All they have to do is waive it. Sometimes buyers will use this addendum when technically they qualify for both properties. And so when push comes to shove and the seller sends them notice, you know what, we accept another offer, you got 3 days. Either waive or you're kicked out. Buyer says, okay. And buyer says, okay, we're gonna waive because we feel really good about what's going on with our property, or we can qualify for both. So buyer still is in control of that, and it kind of creates a little bit of a sweetness for the seller to accept this, because the seller says, you know, I can't accept another offer. I continue to show. Now, the reality is, you understand this from the listing side, once it's under contract, even a contingency contract, number of showings are going to drop dramatically, because a buyer's agent's not going to waste a buyer on a property they may not be able to buy. So the chances of this happening to your buyer are statistically fairly low. But it gives the seller a little bit of that hope.
Okay.
Make sense?
Yes, thanks.
Question 13, and this is a general question. What are the days in the contract or in any addendum to the contract, calendar days or business days? What do you guys think?
Calendar days.
Yeah, it is calendar days, and it's calendar days under all circumstances. We're going to see a conversation about the calculation of the number of days in paragraph 5 of the earnest money. But unless the parties change it, and we see, we were just looking at one the other day, and it was with the relocation company, and in their addendum, they changed calendar days to business days. They create some challenges. There's a certain amount of vagary going on there, in that they need to be very clear that this is the case with all of the days in every place in the contract or any addendum contract. And that can create some consequences. It might be a little bit of a challenge. So as you work through this, but otherwise, all days are calendar days, and except for one case, somebody tell me which case, and except for one case, they're full days to 11:59 p.m., except for which one difference? Or is it not 11:59 p.m.? What's the one case that's different?
Earnest money check.
Nope.
Option fee.
The option period. Option period ends at 5 p.m. on the last day of the option. So it's the option period. Otherwise, all timelines are full days, 11:59 p.m. on the last day of whatever the requirement is. We good? Okay. So question 14, which is a little bit of a tricky question. How many places are there in an executed contract, not counting any addendums, but just the contract itself, for a date excluding the dated signatures on page 8? So how many places in the contract do you see a date as opposed to a number of days? Any guesses? Well, Bob, I'll have to read the contract again. Did you want us to read the contract? I don't remember that as a requirement. No. But there's a concept here, and it's an important concept. So when you look at the contract and you look for dates, not number of days, when you look on the first page, timelines here, Paragraph 5, you've got days, don't you? You don't have a date. Now, when you look in paragraph 6C, you've got days. When you look at objection time frame, you've got days. You look at paragraph 7, 7B2, you've got days. When you look through the contract and we look for dates, look at paragraph 9. We finally have a date, don't we? Any other places where anyone says, well, what about have a date in this one? Except for closing date, except for the effective date, everything else is days. Now, this is important because, and this is just for the contract itself, it helps us understand the concept of timelines and that are tied to days, not dates. Now, that was done intentionally. When I spent my 6 years on Broker Lawyer Committee, one of the things that I learned on that committee was the concept behind some of the choices. And by having days rather than dates, it created a much greater level of flexibility to the buyer and the seller on performances and what they're doing. Rather than putting a written in stone date, something had to be done by, it created a lot more flexibility. And so understanding that we're talking about performance days as opposed to a date, the only other date you've got is a closing date. We good? Okay, so you got some multiple situations in number 15. 15 gets a little trickier, but I know you can handle it because now you've had your after lunch nap and you're ready to roll. I can just tell. So 15, in a contract in which the buyer has rights of termination under 7B2, which we've talked about, option period in paragraph 23, paragraph A1, the mandatory HOA addendum, which we just talked about, and a date in paragraph A of the addendum for sale of the property. Which rights affect the other rights and which one prevails over the other? So all these termination dates, which of these affect any of the other dates, the other rights termination? Which of them say, well, it affects this one. If it does affect, if they interact at some level, does one prevail over the other? This is one of the most important concepts of contingencies performances in the contract. So these terminations, 7B2, paragraph 23, paragraph A1, paragraph A, the sale of the property, are any of them prevail over the others? Any of them affect the others?
Is it the HOA?
They all stand alone.
James is right. Every one of these is independent. None of them stack on top of the others. There is no interaction between them. And the only thing that causes one to prevail over the other is timing. It's probably the most frequent. I'll get a call from an agent that says, hey, my buyer's situation has changed and my buyer wants to terminate the contract. My first question almost always is the property in a mandatory HOA, has your buyer received the docs? And it's amazing how often that's the case that they haven't, which gives them a right of termination right there. All the other rights of termination may have passed, and the only one left might be the HOA addendum. So it's really important for you to understand these all stand separately on their own, working through the process. So any question on 15? We're all in agreement with that? Okay, 16. Do we calculate the 3 days in paragraph 5, which is the earnest money? How do we calculate 3 days? And what effect does a weekend or holiday have on that calculation? It gives you an example. Effective days on a Friday, Monday is a federal holiday, or the effective day is a Friday, Monday is not a holiday. How do we go through the process of calculating when the third day is? How do we do that?
It's after the execution and delivery, isn't it?
Now,
Of the
they're
contract?
they're all tied to the effective date. And so, you know, when you look at paragraph 5, it talks about within 3 days after the effective date. So when we're counting these days using 3 days after the effective date, what kind of days do we use? Calendar days, business days, and what effect does it have? How do we get to that third day? So our example, contract's effective on a Friday. Does the fact that Saturday and Sunday are the weekend and Monday might be a holiday, does that affect how we get to the third day?
We don't count weekend, right?
That's what I'm asking you. Do we?
No.
Yes, I do.
Count
Bob?
weekends, but not holidays.
Correct.
Okay, so we count weekends but not holiday. So in the example where we got a weekend and Monday's a holiday, you're saying
It
that
would
getting
move-
to the third day, we'd ignore the holiday Monday, so our third day wouldn't actually be till Tuesday? So we'll count the weekend, but we would not count the holiday to come up with our third day? Is that what I'm hearing?
Yes.
Yes.
Okay. So you're not going to feel like I've tricked you if I tell you that's wrong. Here's the concept. The language in paragraph 5 is what creates the challenge. Because when we get to that third day, we do have language that says if that third day is a weekend or a legal holiday, then the time for the buyer to deliver the earnest money must extend to the next day that's not a weekend or legal holiday. Right? My co-worker out there barking. Okay, so here's the concept. Friday is the effective day of the contract. Monday's a holiday. We want to get to our third day. Our third day, Saturday, Sunday, Monday. Monday is our third day, but Monday is a legal holiday. So we'll go to the next day that's not a legal holiday or a weekend, but we got to that third day with counter days. We don't skip weekends. We don't skip holidays to get to the third day. It's just that once we get to the third day, we then have to decide what we're going to do with the buyer's requirement to put the earnest money with the escrow agent. And the reason kind of for this is we're talking about delivering the earnest money to the escrow agent, which you can't do if they're not open. Actually can, but we've seen cases in which we had to meet with somebody at the title company outside of their business day to be able to tender it because we were on the third day. So if we've got a contract and the effective day of the contract is a Tuesday, first day is Wednesday, second day is Thursday, third day is Friday. We know the buyer must have the earnest money of the escrow agent by Friday, or the seller has rights termination. But if we've got a weekend and a legal holiday, that still, each of those days still counts in getting to the third day. It's just that once we get to the third day, what that third day is will determine whether or not the buyer has to deliver by that date or can move to the next date that's not a weekend or legal holiday. We see the distinction there?
Yes, but I have a question. Now that we have Zocam and now that we have the app, is delivering earnest money funds on a holiday still not included as one of those days because technically the banks aren't open?
Okay, so if you're delivering electronically something to the escrow agent and they're not open, first of all, if your third day is a weekend or legal holiday, while the seller, because of logistics or a buyer, you leave town or the country or whatever, says, well, I need for us to go ahead and deliver this now, you can deliver it. However, because it came on a weekend or a legal holiday, the seller can't require delivering that time frame. They've got to give the buyer that extra day past the holiday or the weekend. That makes sense?
Okay.
Because we are moving more and more to the electronic delivery. And we're going to see that even more with the new provisions and the contracts being proposed in November. So we're going to see that more. So the key is it does. Now, there's another part in the language in paragraph 5 that deals with this. The seller has rights of termination. You know, we've gone through the process and the listing agents help the seller calculate the 3 days. And so we're now, in 3 days has passed, we're now on the 4th day. There is no automatic termination. All it does is gives the seller a right of termination. But that right of termination of the seller is tied to the seller has to terminate before the buyer finally delivers the earnest money. So we're on the 4th day, and the seller's been pretty busy that day. So on the afternoon of the 4th day, the seller says, okay, you know, we're in 4 days now. I don't think you're ever going to give the earnest money. We're going to terminate the contract. So the seller sends the termination under paragraph 21 over, but without knowing that late that morning, about 11 o'clock that morning, the buyer finally got the earnest money to the title company. Well, that took away the seller's right of termination, even though they're on that 4th day. The other part of that is the seller's not required to make a decision on that 4th day. Seller may say, okay, I've been told, I understand, people are busy, things happen, we'll give them more time. The seller could be 5 days down the road, 10 days down the road, before he finally says, okay, you know, that's enough, buyer didn't get it to us and we're going to terminate. So it's not an automatic, seller just has that right, but the seller can choose to give the buyer more time. They want to work through that. But it has to be, the seller's right of termination has to be before the buyer delivers the earnest money to the escrow agent, and they could do it, as Jana pointed out, electronically, and as long as the title company has received it. If you send electronically, what we're going to find ourselves dealing with are case studies in which they electronically send it to the escrow agent to a site on a Sunday or a legal holiday, and they don't receive it until the next day. The fact that they did it in the time frame, is that sufficient, or does it need to be received from the other side? We don't know. So it's going to depend on, you know, how that gets worked out and how the parties decide to deal with it. We've got some situations that are going to still be up for question, and we're still going to have some test cases to work through it. Everybody good with paragraph 5 so far? How that works? Okay, so 18, our last question. What is the most likely effect of not filling in the information asked for in a blank of the contract? A, it may cause the contract to be unenforceable. B, it may cause a party to have rights greater than the other party anticipated. C, certain blanks ask for information that ultimately have no effect on the validity of the contract. D, as a minimum, a blank left blank creates a possible dispute between the parties as to the terms of the contract. E, not completing a blanket paragraph will in effect void that paragraph. So which of those do you think is the most likely? Which of those would be the one that we'd say, wow, that's more true than the others? Because there are actually a couple of them that are kind of true, but one is more true than all the rest. What do you think?
I would say B and E, but E would be my final choice.
D.
You think that if a blank in a paragraph is left blank, it voids that paragraph?
No. I'm sorry. D is in David.
Okay. Okay, so D, it creates a possible dispute. I like D a lot.
A.
Like A?
Uh-huh.
Okay, A is absolutely not correct.
Okay,
It
sorry.
does not cause the contract to be unenforceable. All we have is a point in the contract that may be in dispute, but it doesn't make the contract unenforceable. It may create some challenges for enforceability, depending on what blank we're talking about. Now, there are some blanks that are incredibly material, incredibly important. Paragraph 3C, for example, which is the sales price. If you leave that blank, we have trouble, because we don't know how much the seller is going to sell for, how much the buyer is going to buy for. And enforceability of a contract is going to be a real problem, because the judge is going to say, okay, show me again where the meeting of the minds is. You say the seller is selling the property $300,000, the buyers agreed to buy $300,000. Where do I see that? Nowhere. That may create an unenforceability. So some paragraphs, some blanks are so critical, it could. But you've got a whole room full of attorneys on the other side saying, no, 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 that's a dispute, and here's how we settle it. But B, it might give a party more rights, the other party anticipating, because here's the challenge. In paragraph 6D, objections, you've got a number of days to object. And I see this number of days left blank. And the typical position of a buyer is when they see that blank, they say, you know, this number of days and this blank is a limiting number of days, is blank, and that means I have all the way to closing to make an objection. Well, that's almost certainly not what the seller intended the buyer to have. So a dispute like that might give a party on the other side more rights than was intended in the contract. So I like B a little bit. I clearly like D the best. Now, you could make a case for C. There are some blanks that really have no effect on the validity of the contract. Paragraph 21, that paragraph, which is our notices paragraph, gets left entirely blank a lot. Now, imputed notice now applies. You can send notices to the agent, same as sending notice to the client. But paragraph 21 being blank doesn't void the contract. It creates a problem for the title companies to know what address we're going to use, send from the buyer and the seller notices, but it ultimately has no effect as you work through it. So I agree with Jennifer. I like D the best because as a minimum, it creates possible dispute as you work through that. So those are my 18 questions. It takes us in the contract and certain addenda to the contract. And I'm certainly open for you guys to say, well, wait a minute, Bob, what about? Or let me give you some additional information here I've got here. I'm open for that. I would like to ask the question, if you feel like going through this and getting some information, work through these questions to get into certain parts of the contract and the addendum were helpful at all and cause you to realize and think of some things that maybe you hadn't totally thought through before. Was this helpful at some level?
Always helpful.
Yes, thank you so
good,
much.
Good. Okay. So
we have some of our newer agents on here, and we had a question. They commented, yes, this was helpful, but what is the effective date of the contract for our brand new agents? We have some brand new agents on here.
That's a great question. We did a class before you got here a couple of months ago on the process of getting to an offer to the effective date. And the effective date of the contract is not a simple or easy thing, but here's the process. And let's take the first easy, simplest. Buyer makes an offer, and when the buyer makes the offer, they completely fill out the offer, the contract form, and any addenda. They initial the bottom of the first 7 pages. They sign page 8. They sign the addenda. They send that over to the seller through the agents. Simplest scenario, seller accepts the buyer's offer. No changes. So the seller initials the bottom first 7 pages, signs page 8, signs all the addenda, and the seller then tells their agent, you know, we've accepted the buyer's offer, no changes, communicate to the buyer that we have an executed contract. At that point, in the simplest scenario, when the listing agent communicates to the buyer's agent, my seller has physically done everything they're required to do, they've initialed, they've signed, we have an executed contract. At that point in time, one of the agents, in that case it would probably be a listing agent, goes ahead and puts a date on page 8 right underneath paragraph 24, and that's the effective date of the contract. That's the simplest scenario. Offer, acceptance, contract. The critical thing about the effective date, though, communication has to happen. Delivery does not have to happen, but whichever side fully accepted the other side's offer, that side, when they accept it, their acceptance has to be communicated back. So if we go back and forth several times, buyer makes an offer, seller makes a counter offer, buyer makes an offer, and so finally one of the parties, maybe the buyer, finally accepts the last counter from the seller. the buyer initials off on the change. Everybody has already initialed on the first 7 pages, signed page 8, signed the addendums. So this final step of the buyer, initialing that last change, maybe the price, that acceptance, and then that communication from the buyer's agent back to the seller. The buyer has fully accepted your seller's counter. They've physically done everything they're required to do. I've now dated the contract. That day the contract is today. That's how we get that effective date. Our challenge comes from two things happen. One, they don't fully communicate back to the other side that acceptance has happened, or they communicate and imply acceptance before it's actually happened. The listing agent, for example, may say, yeah, I've got this to my seller. He likes it. My seller is really good with this. He's really accepting this. I think we got a contract. I'm going to get with my seller at 8 o'clock tonight for him to sign off on everything. Oops, we don't have a contract because it hasn't happened yet. The communication of an acceptance has to be after both sides have fully physically done everything they're required to do. So if that seller says, I've accepted, but he hasn't really signed off on everything, we don't yet have a contract. The other challenge that happens is we have accepted, we have communicated, we have a contract, and no one thinks to go back to page 8 and date the contract. We still have a binding enforceable contract. We just have a dispute on timelines that are tied to the effective date because no one put a date in there. At some point in time, the title company is going to realize, whoa, we don't have a date. And they'll call the agent up and say, hey, we need a date. It doesn't mean we don't have a contract. It means we've got a dispute on performances. We don't know when the option period ended because we don't know when it began. Does that kind of help with how we get to a contract and to that effective date? Now, I do want you to recognize something that I never was able to get this changed, but when you'll notice on page 8, it has a phrase in there that gives me great grief and shouldn't be there. When you look down at the signature block, executed the blank day of effective date, and it says broker, fill in the date of final acceptance. Do me a favor, don't call me or Mike Brody 10 o'clock Saturday night. Hey, great news, finally got my first contract. I need for one of you to come over and date it for me. You have our permission to date it. If you're the last agent who your client fully accepted and you communicated that, go ahead and date it. It's within our policy procedures. You have that authority to do that. Don't call Mike Brody Saturday night, 10 o'clock. Say, oh, Mike, come on over and date this thing for me. That's what it says, but that's really not what happens in the real world. Thank you, Laura, for the hand. Okay. Any other good questions? That was a great question, because we do have that challenge. And in line with that, new agents, as you're going back and forth, especially if you have a seller, don't be using phrases. If your seller says, this looks good, this looks great, well, I think I'm going to accept this, don't say anything that would cause the buyer side of the transaction to think they're in a contract. Don't use phrases like, yeah, my seller will do that, or we've got a deal, or this looks good, let me go get the paperwork done. Don't use any of those, because buyer's agents and buyer's agent will tell their buyer, oh, good news, you got the house. You got it. Great news. But before the seller finally signs off on everything, and that's communicated, another better offer comes in that your seller wants to take, which they can take because they're not in contract yet. And that creates a huge challenge. We've had to settle at least one lawsuit on exactly that, because the agent made a mistake of using the phrase, great offer, we got a deal. Well, we didn't have a deal. Work through it. So great question. Everybody good? Any other questions, anything you want to come up with? I appreciate everybody being in this class. Great turnout, really good. I'll have an advanced contracts class towards the end of the month. I don't remember the date, but whenever. And hopefully as many of you can will make the mega camp, which we're doing virtually this next week. I think it's next week. It starts next week. And please make use of our agent hotline when you have questions every day during the week, nights up till 9 o'clock and weekends. Because we got 4 agents there who are really doing a good job of answering those tricky little questions. If you don't have anything, guys, I'm through. I'm done.
Bob, thank you so much for your time.
Thank you guys for being here. We appreciate
Thank
it.
you very much.
Thank you, Bob.
Thanks, Bob.
Now we can leave the meeting. I'm done.
Thanks.
Okay.